Kia ora koutou katoa. Welcome to the Commerce Commission's webinar on changes to the Grocery Supply Code. Thank you very much for signing up and joining us today. My name is Dr. Alice Hume. I'm the Head of Grocery here at the Commerce Commission. I'm going to be joined on the webinar today by Laura Furneaux, who's our Manager Grocery Competition, and Catherine Sayer, who's Chief Advisor in Laura's team. We're just going to run through a few housekeeping matters before we start, and then we'll get into our agenda. So today we are going to run through just a bit of background on the supply code. Then we're going to talk through the changes that we have made to the code and how those changes will be implemented, talk a bit about breaches of the code, and then there'll be an opportunity for Q&A. We have a lot of people registered for our call today, and that's a range of sector people, including representatives from the supermarkets and from suppliers. We'll be using the question and answer, the Q&A function at the bottom of your screen. If you want to ask your question anonymously, then just please select the anonymous question and then you won't be able to be identified. We'll try and answer all of the questions that we receive in the webinar today. If we're not able to do that, then we will be providing written answers to questions after the webinar. We're also recording today's session, so you can rewatch it, or you can encourage other people who may have missed it to watch it. So what is the Grocery Supply Code? Why are we here to talk about this? So the Supply Code came in under the Grocery Industry Competition Act in 2023, and it sets out the rules of engagement essentially between the supermarkets and suppliers. So the supermarkets and the banners, their banners on this slide, are the regulated party, and the supply code puts obligations on them in the way in which they deal with suppliers. And the reason that this set of rules is needed is essentially because there isn't enough competition in the sector. We don't have enough supermarkets competing with each other, and therefore we're very aware that the balance of power of the supermarkets over suppliers, as there's a significant imbalance there. And so these rules are in place to address those and to provide protections to suppliers in their dealings with the supermarkets. So the code, to those ends, the code's intended to promote fair conduct and prohibit unfair conduct between the RGRs, the supermarkets, and suppliers. It's about promoting transparency and certainty about the terms of the agreements between the retailers and suppliers. So we know that in the past there's been a significant volume of trade on the basis of sometimes no written agreement at all, and that suppliers had a number of questions about the actual terms of some of those agreements. So being able to understand what terms you're being asked to sign up to, and what the benefits to you from those terms are, is a really important element of the regime. The code contributes to a trading environment in the grocery sector that includes a diverse range of suppliers and in which businesses can compete effectively. So we know about the commercial pressures of supplying the supermarkets and about the potential uncertainty about ongoing stocking of your goods. And so that's one of the areas in which the supply code helps to support clearer communication of what the processes are that apply to key processes like delisting. And the code also contributes to grocery sector um, in terms of enabling consumers and businesses to participate more confidently because the essentially terms of engagement are better understood. As part of the Grocery Industry Competition Act, we were required to review the supply code within 2 years of it coming into force. We have heard the feedback that there's some concerns about the rapidity of that review. And so, just to reassure you that when we started the review, we did look at making sure that we were really identifying areas where we felt immediate change was needed. There were a lot of other issues that were raised as part of our consultation rounds that we have chosen not to implement change this time around because we wanted to allow time for the code to bed in. That would be kind of normal regulatory practice to allow a new rule system to settle in before you started making changes to it. So we really focused our changes on areas where we felt there was an immediate need for change and that had been highlighted to us through the consultation. So we did end up making a number of changes, and those are included in a new supply code. Much of the code is the same as the old code, but the way in which we update it is to essentially adopt a new code, and that comes into force on the 1st of May, which is tomorrow. So uh, following that coming into force, the supermarkets have 1 month, so until 1st of June, to offer suppliers new supply agreements or to vary their existing agreements. So our understandings from discussions with the supermarkets are that they are taking a range of approaches to how they're going to to contact suppliers about new code terms. So maybe that you get a full new document with the key changes flagged up, or it may be that you get a set of variations that sit on top of your existing terms. If you don't understand what changes are being made, that's something that you should be asking for clarity on from supermarkets. We understand that a lot of these conversations have already started. So if you have concerns about what you're being asked to sign up to or about the process for transitioning to the new code, we'll provide information at the end of this webinar on how you can get in touch with us about those concerns. I will now hand over to Laura Furneaux, who is going to go through the detailed changes that we've made to the code.
Thank you, Alice, and kia ora koutou. Thank you again for joining us for this webinar. As Alice mentioned, I'm Laura Furneaux. I'm one of the managers in the grocery team. I work specifically on a couple of projects at the moment around assessing how regulation and rules are working under the Grocery Industry Competition Act and whether changes are needed. So you've likely also seen my face around a wholesale supply inquiry as well. But the focus today is on the changes that are coming into force for the Grocery Supply Code tomorrow. So before I talk about the changes, I just wanted to do a quick recap on the rules in the code because I recognise there are many there, and just to reinforce that the majority of the rules haven't changed, and this includes fundamental things such as the first one at the top of this list, the obligation to deal with suppliers in good faith. And the second one in this list, that grocery supply agreements must be in writing. So the majority of the rules have stayed the same, but we have made some changes. They are highlighted in red here, and I'll talk about them in more detail. We have also shifted the location of a couple of the clauses, which means there's a small amount of renumbering. So I've just highlighted those two there. That was the clause related funded promotions moves closer to funding promotions, and the clause 27 transfer of intellectual property rights has moved below intellectual property rights. So we just while we were doing the review and making the changes, we have done some, I guess, changes to make the code more readable. So I just wanted to explain that. Uh, so if you're not familiar with all of those rules, I do encourage you to uh, have a good look at them, and please do ask us questions or get in touch about any of the rules there. As I said, there's some fundamental things that they cover there, as well as some specific things around ranging decisions, processes that need to be followed, confidentiality. There's a lot of really important information in there. So please do engage with us on the rules more broadly. But today, I'll be talking about the key changes that are coming into effect tomorrow. So those changes relate to prohibiting payments for wastage, new record keeping requirements for retailers, changes to address the practice of investment buying, and a new clause prohibiting retaliation. I'll talk about each of those now. So the first one, which is about changes to payments for wastage. Now, this is one of the rules where it's easiest for me to explain the change by explaining what the existing rule actually says. And the existing rule allowed for RGRs to require payments from suppliers for wastage that occurred while the goods were in the RGR's effective control, so within their store or within their storage once they've taken control, but only under very specific circumstances. And there are a few clauses in the code that have this sort of design to them. And so they mean that the payment can only occur if certain requirements have been met. And this has also been referred to as a carve out. This was discussed quite a lot in our review of the code. So we did look at all the clauses that do have that sort of carve out feature to them very closely. And in this case, the decision was to essentially take away the ability to make those charges even, take away those kind of exceptions or requirements, and remove that provision in that sense, and just make it one clear blanket rule that there can't be charges for wastage that occurs while in the RGR's effective control. For some of the other clauses that have those carve-outs or exceptions, we didn't actually make changes to the clause themselves. So for these ones, clause 9, which relates to unilateral variations to grocery supply agreements. So that's circumstances where the RGR can make a change to your supply agreement. They don't need you to sign off on it. That again can only happen in very certain circumstances. Clause 15, which relates to suppliers making payments for stocking or listing groceries, and clause 17, which is an area that we understand is used very commonly around requiring supplier payments or taking supplier payments to fund or fund a promotion. In all those areas, certain requirements need to be met for those payments to occur. And so rather than changing the clause or the ability to do that, the flexibility to do that, the decision was to add some record keeping requirements for the retailers about the use of or that sort of conduct and activity that not only is another incentive or prompt for the retailers to think about whether they're meeting the requirements, but it creates records that the Commerce Commission can then access and check as well. We don't foresee this creating a significantly different administrative burden because this sort of decision making should have been occurring prior to these changes coming into effect. So it's primarily about making sure that there is a record in place that we can access. Further point to note, so I've been talking a bit about these clauses with carve-outs or certain requirements that need to be met. Another clause that falls into that category is clause 16, which relates to payments for retailers' business activities, and that could include things like merchandising. Now, we did look very carefully at that clause as part of the review, and we did consider making changes to the clause. The final decision following feedback received through consultation in that review was not to make changes at this time. So there's no changes to that clause. But we will continue to monitor these types of payments closely and really watch how that clause is being used in the future. Just wanted to note this while we're having this discussion to just make that clear that we did look at that one, but there are no changes to that one at this stage. Now, this next change, it relates to the clause which is about funded promotions. So I mentioned a little earlier that there is a clause about funding promotions, and this is the clause that we've moved to kind of sit underneath it that relates to certain obligations once those funding agreements are in place or related to those funding agreements. And so this was originally clause 20, but we've moved it up to clause 18. And under the existing rule, suppliers and RGRs were required to agree in advance how to deal with stock bought from the supplier at a promotional price in connection with a promotion to consumers that is not sold within the promotional period. And so the change that's been made to that clause was made in response to concerns around investment buying and I guess the amount of stock that could be bought at that promotional price and then not sold on to consumers in connection with the promotion. And so the change is that RGRs must either only retail the products at the promotional price that was agreed in connection with that deal, or to repay the supplier the related portion of the promotional funding. Now, we realise that there are other sorts of deals that you might do to have supplier funding towards a promotion or to clear stock for a specific lot of stock that you're trying to move. This clause really specifically relates to those circumstances where there is an agreement that relates to a promotion that consumers would receive. So we have a basic example here, and I do recognise this is just conceptual. We're not suggesting that this is a simple exercise in any means, but this is just to explain the concept here. So the idea that on 2,000 cans, the supplier might agree to fund $2 consumer discount. If the RGR sells 2,000 cans and provides the supplier would provide $4,000 funding to cover the discount. Then if the RGR only sold a portion, so in our example, 1,500 or 3/4 of the cans during the promotional period, then revert to a non-discounted price after that the RGR must either repay the supplier that portion of the promotional funding. So in this case, a quarter or $1,000, or it needs to be sold at that promotional price. Now, moving on to the last key change to the code here, and there will be an opportunity to ask questions, as Alice has said, through the chat or directly with us after this webinar. So this clause relates specifically to a prohibition on retaliation by the RGRs against suppliers. So this is what I'm calling an additional rule, because there are already protections in relation to this within the existing code. But we know that this is a significant concern, and Alice talked earlier about the imbalance of power and the ability for suppliers to actually assert their rights under the code, and to raise concerns around what impact that might have with the retailers in the future. So this, the existing rule falls under the sixth, which I mentioned before, the obligation to deal with suppliers in good faith. So when determining whether the retailer was acting in good faith, one of the factors, and there's lots of things to consider in relation to whether the behaviour was good faith, is whether the retailer had acted in any way that constitutes retaliation for past complaints and disputes. So as a result of the review, we added an additional rule, and this has also been added to the Australian Code, that expressly, instead of it being a factor that's part of that good faith consideration, there's an express rule here where we're really spelling out that that the regulated grocery retailers are prohibited from retaliating against suppliers for exercising their rights under the Grocery Supply Code, contacting the Commission, or engaging with the grocery industry dispute resolution scheme. So that's another pathway associated with the code, and an independent pathway for raising disputes and concerns related to the code. So we have also included that expressly here within the code to further address concerns around going and using that service. And the wording in the clause also acknowledges that retaliation can take a range of forms. So some of it, retaliation could be quite explicit, or some could be in other sorts of behaviour. So the code does cover that as well. So that was a quick overview of the changes. As I said, I'm very happy to take further questions, or we can discuss these direct with you. I'm going to hand over to Catherine now, who's a chief advisor in my team, to talk about the process of implementing the changes, as well as to talk about breaches of the code.
Kia ora koutou, ko Catherine Se Tokuwenua. I work in grocery policy and monitoring and compliance, but almost all of the work I do here at the Commission ties back to the Grocery Supply Code. I have a background in science and law and policy, but my most relevant qualification for my current role is having worked on the deli at Sainsbury's in London while I was a student. So I have a superpower of being able to judge the weight of a block of cheese or slices of salami by sight. But don't worry, no Weights and Measures Act offences were committed during that stint. I was required to use the scales. So as Laura's mentioned, I'm going to talk about implementing the changes. And don't worry, I go over quite a lot here because we put up some fact sheets and material you should have been alerted to yesterday on the website that goes into this, again, in a written format. So as a supplier, first of all, it's really important that you keep informed of your rights under the Grocery Supply Code and be prepared to assert them. We'd also encourage you to understand what the supermarket's obligations are under the code and to respect them. Having a grocery supply agreement, which I might abbreviate to GSA, that's a really good way to do business because it'll contain or refer to all the terms that are relevant to your dealings with the supermarket. So negotiating a GSA is your opportunity to raise matters that are important to you and your business, and it needs to be consistent with the code. We should let you know that as the Commission, we can't write GSAs for the supermarkets, nor can we give suppliers advice on specific agreements that you're presented with. But since it's such an important document, getting independent legal advice on a GSA might be a really good investment to help you as suppliers understand what your rights and liabilities are and to help you negotiate fair terms. All right, we've saved the most exciting topic till last, that's the paperwork. So, Alice has mentioned this at the start, but by the 1st of June, even if you're not already operating under a GSA, any of the regulated supermarkets you're trading with does need to offer you a grocery supply agreement that is consistent with the new code. And as was mentioned earlier, there are two approaches we're aware of in relation to putting out consistent GSAs. One of them is for the retailer to prepare a variation to your existing GSA, for those of you that already operate under a GSA. And this variation will be a short document that makes changes to specific parts of an existing GSA. Once it's agreed, it becomes part of the GSA, the long form GSA you've already got, and it needs to be read together with that original GSA. The other approach that some of the supermarkets may be taking is to present you with a completely new document. So this would be a long document that covers all aspects of trade between the two parties. So you'll get presented with one of these if you don't already have a GSA, but the retailers may choose to do this for all of us existing suppliers. So if you already have a GSA, the replacement one should have a term explaining that it supersedes the previous one. It's important to note that in almost all cases, what you're presented with won't have legal effect at that time. The ball's on the supplier's foot to respond to the proposal. Now, an important exception is a unilateral variation, and that's a right in an existing agreement for one party to make changes that bind the other party. So if the retailer sent you a variation document and tells you that it makes changes that have effect without needing your agreement, so it's asserting a unilateral variation right, it's a really good idea to take legal advice. Now, apart from unilateral variations that already have effect, there's no actual due date in the code by which you need to respond to the proposed terms. However, it's possible that your retailer can't continue trading with you from tomorrow on exactly the same terms as before, because it would otherwise be in breach of the code. And that's particularly the case when it comes to investment buying rules that have changed. So there may be some circumstances where your retailer can't continue doing business exactly as you're used to, even though it might quite like to. So in that situation, both parties will need to adapt their trading terms fairly swiftly. Where time is an issue for co-compliance reasons, your supermarket should be very clear about this. So, what next with this document that you can now confidently identify as either a variation or a complete replacement GSA? Alice has mentioned this earlier, but it's really important that you read this document. It's important that as a supplier, you're up to date with what's required of you. And again, as Alice mentioned, you need to understand it. Under its good faith obligation under the code, and that's stayed as clause 6, your supermarket should be explaining the changes it's made or it's proposed, why it's proposing them, and how they affect you. So your first port of call, if you don't understand these changes, is to go back to the supermarket. And if you still don't understand, or you need detailed advice on the implications, really consider obtaining legal advice. If you disagree with the proposed changes, it's your right to voice this, but you need to be prepared to negotiate until you reach a position you're both comfortable with. Now, the code doesn't prohibit hard commercial bargaining, so suppliers can still expect pushback and robust discussion, but it does require that bargaining is conducted in good faith. So this would involve both parties having relevant information at hand and the opportunity to voice their unique circumstances and have them considered. Now, if after this negotiation you agree some changes, it's important that the retailer might draft up those changes in another revision. So it's important that you check carefully what those redrafted provisions say to ensure that they put into effect what you think you've agreed. And again, if you're not sure, consider obtaining legal advice. When it's signature time, it's really important that you only sign material that you've read, you've understood, and you agree with. Let's now turn to some implementation pointers for the retailers, and I'm expecting this all to be very obvious to them and already in hand. First of all, be very clear on what the code updates mean for the way you do business. Make sure you've set up systems and processes that enable you to meet the code. And that means making sure everyone on staff who deals with suppliers understands their obligations under the code and is familiar with any tweaks you've made to your systems and processes to deal with those code revisions that Laura talked us through earlier. Identify all the supplier agreements, all the GSAs that are inconsistent with the code, and propose code consistent versions by the 1st of June. And when you reach out to suppliers, and some of this may have already happened, provide really clear explanations on what you're changing and why, and identify the code change that's driving that revision proposal. Ensure that you're satisfied you've met the requirements of the code when you're asking a supplier to contract out of a protection, which we call relying on a carve-out. And don't forget that even if the suppliers agreed to a carve-out, if what you're asking isn't reasonable, the term can't be enforced. And make sure you negotiate in good faith if suppliers come back with alternative suggestions on your proposed variations. Right, let's move on to talking about how the code is enforced. So the code has potential to level the playing field between the major supermarkets and the smaller suppliers, and suppliers of all sizes, really. So we take compliance very seriously. And the focus of our work is getting fair processes occurring along the supply chain so that outcomes are durable and that they result in real change. So not surprisingly, the Commission's got powers to monitor the state of compliance with the code. And where this isn't happening, the Commission can investigate individual cases and take enforcement action. Now, you might recall that earlier this year, we identified instances where we considered Woolworths at risk of not meeting its obligations under the code. So we investigated, and this resulted in Woolworths being issued with a warning. So it's subsequently updated its processes to meet its code obligations. And the other retailers told us that they followed our compliance work very closely, and they reviewed their own processes to ensure that they were meeting Commission expectations. So this shows the power of individual cases to shift the dial across the board, across all the regulated supermarkets, and to achieve that culture shift that we're looking for. If a code compliance case does reach court and a breach is proven, there are significant consequences, including pecuniary penalties, and that's just a fancy way of referring to fines. So for an individual, the maximum pecuniary penalty is $200,000. In other cases, where the breach is proven against a company or a cooperative, the fine is the greater amount of $3 million or whatever the actual commercial gain is. And if the actual commercial gain can't be established, it could be up to 3% of the group's turnover. If you think a breach has occurred, you do have a few options. First option, you can discuss it with the Commission by reporting a concern via our website, or you can use email or just call our 04 Wellington number, which is on the slide. Alternatively, if you want to report your concerns anonymously, there is an anonymous reporting tool available. That's an online tool, and there's a link to that on our website. So this uses it's a global international whistle B system, which is designed to use extremely high data security and privacy settings. And that tool encrypts any data and information provided. The downside of its extremely high security settings is that we cannot get back to you directly on any information put into that system. It all happens indirectly. And so it requires you to check in from time to time on what's happening and what our response is. You have to be a bit more proactive than a normal direct engagement. The third option available to you is to use the independent dispute resolution scheme that was also mentioned earlier in this session. So that helps resolve disputes between suppliers and the regulated grocery retailers. And it's operated by an independent body, the New Zealand Dispute Resolution Centre. So there's more detail about this scheme and a link to it on the grocery pages of our website. So just to finish off, lastly, and thinking more widely than just about breaches, we hear quite often that businesses feel that the Commission might understand the theory of running a business, but not so much the reality. So the way we as Commission staff deepen our understanding is by businesses engaging with us. Now, the regulated supermarkets, they're very good at letting us know when we're missing the point or might have overlooked something that's really important to them. And it's absolutely right that they do that. So we'd also encourage suppliers to take advantage of our listening skills and reach out to us with their questions or concerns. So talking of our listening skills, I've probably done enough of talking to you. So it's time for us to listen to your questions. So what I'll do now is hand back over to Alice, who will marshal this part of the session.
Thanks, Catherine, and thank you, Laura, for your parts of the presentation. We've got lots of questions, so let's get stuck into them. I think one of them is probably a result of my omission at the start around sort of what happens next. And I just wanted to give a bit of clarification around where the onus sits. So the onus very much sits with the regulated grocery retailers to offer the new terms. There is no time limit on suppliers for considering those terms. I think what we would say, though, and to Catherine's point, there may be elements of your trading terms that can't be given effect to if they're not compliant with the new code. And so you need to have a good understanding of the implications of not agreeing terms on your ability to do some of those things. I think the other thing I just highlight at this point is that the protections of the code do apply whether you have signed and agreed terms or not. But I guess our view is that if you haven't signed terms, then there will be, if there is a dispute, there will be more onus on you as a supplier to secure those rights yourself rather than them being in those terms. So it just may add some additional process steps when you go about trying to assert your rights under the code. So that we would ask you to think about that in any consideration. But there are a few specific questions about what happens next as well. And so particularly around the ability to negotiate terms. So robust commercial negotiation is still supported and encouraged under the code. what the code is trying to do is to stop terms that you don't agree with being imposed over the top. And so to Catherine's last point, if there are terms that you're being offered that you have concerns about that you think may not um, be allowed under the code, those are things that we would like to hear about. But we do have a specific question around where the GSA sits, whether it's with head office or store. So I'd invite Catherine or Laura to come back and just talk a bit about that because in a sense, they can apply at both levels, and so it'd be good to talk about that in a little bit more detail.
Alice, yeah, so the question is, are GSAs only signed at the head office level, or are they required for each individual store that a supplier might trade with? Ultimately, it's up for the regulated supermarket to manage how it wants to handle the paperwork. It, I think in most cases, the regulated retailers would manage it at a central or head office level. But if there's any other arrangements you have in relation to the supply of groceries with a store, a technical reading of the code says that that side arrangement should also meet the requirements of the code. And there's provisions about what the content of a grocery supply agreement should cover. But even if dealings you have with a store aren't subject to a written grocery supply agreement, your dealings with that store are nevertheless protected by the code. But ultimately, I would go to the central or head office team for advice on the extent to which they'd be looking for you to have a written agreement at the store level.
So
have you got anything else to add, any of the other panelists?
I guess the other thing, obviously, we're aware of the number of store level agreements that went out the first time when the code first came into effect, and um, and the effect that that had on suppliers. So that's something that we have been discussing with the supermarkets. But yeah, to Catherine's point, there may be some store specific terms that do need to be captured in the agreements that you have. Laura, did you have anything to add here?
No, not on this point. No, but happy
Oh,
to
good.
take some more questions.
So one of the other questions that came up that's also, I guess, in the same area is about which of the RGR entities the GSAs apply to. So the question was specifically about Trents and Gilmores, but would one of you like to just cover that off?
So the Act specifically spells out who's subject to grocery supply obligations under the code, and that does include the associated entities. So that does include Gilmore's and Trent's. What I would say is that our legislation applies to groceries as defined under the Act. So we have had some questions about this before because a common question has been around alcohol and whether that is included in our definition of groceries, which alcoholic drinks are not. So would just encourage you to get familiar with that definition. Think about your specific business and how it applies within that definition. Our fact sheet should also help give you some guidance. But if you have any follow-up questions or concerns, and you want further kind of detailed questions around this, feel free to send them to us.
There are a lot of questions about effective control and the changes that we've made there. Catherine, would you like to talk to that in a bit more detail?
Sure. Yes, the clause 14 wastage provision and the changes to that have raised quite a few questions, one of which was, does clause 14 mean that ullage or MDA, that's minor damage allowance terms, necessarily need to be removed from GSAs? What I would say is the code isn't specific on striking out any particular types of wastage payment. The code is written in a more principle-based way when it comes to wastage. So a retailer could charge for something that they call ullage or minor damage allowance, but if they do, they need to be absolutely sure that it does meet the requirements of the revised code. I'm not sure if that's desperately helpful, but because of the changes, when the regulated supermarkets are coming back with changes to their terms of trade and their GSAs, they should be explaining why those any wastage type payments that are left, why they are meeting the requirements of the code. So the onus is on them in a way to explain to you why any wastage type requirement is still good to go. Or they may have adjusted the wastage terms altogether to deal with the code. And so there should be very clear explanations that are provided to you as to what those new wastage payments cover. And if you're in any doubt, perhaps consider legal advice. Now, there were some other very specific questions on wastage, which I think we will take away and come back to the group, to all the session attendees in writing, because they involve a fair bit of detail.
Yeah, so there's a lot of questions around if the supplier being responsible for stock ordering means that they have effective control. So we will provide a written answer about some of those. One of the things that we've brought in as part of this review of the code is some more requirements about record keeping. The onus for the record keeping and the providing justification for various practices sits with the supermarkets. Do we have anything more that we'd like to say about that?
Yeah, it's quite early in the piece for us to have an explicit view already on what best practice looks like. But I do note that the code requirement is that the record needs to be a written record. So at the moment, how that's done is really up to each regulated supermarket.
This will be something that we'll be checking in on as part of our ongoing monitoring of how the code's been implemented. So, yeah, we will be keeping an eye on how that's going. Just having a look at some of the other questions here. So there are definitely a number of questions, as there always are when we talk about the code, around delisting. And so the specifics around delisting and what's required haven't changed, but maybe a good time to just remind people what protection the code does bring in relation to delisting. So largely that's around clear and transparent processes and the ability to to give feedback and to challenge those processes. Is there anything that Laura or Catherine you'd like to add in relation to delisting?
Just like to acknowledge that as an area that that we have had feedback as being kind of the key concerns for suppliers. So previously heard through a variety of sources, including our supplier survey, and we have just run another survey, which we're just awaiting results from. We are aware of the concerns and as an area that we're looking closely around the conduct that occurs here. I do, while Alice is just looking at some of the other questions, we have received some specific questions about opting out of certain types of payments and I guess implications that might have during a category review and discussion as well. I think just to emphasize that we do have those multiple clauses that are relevant to this. So the clauses, clause 17 around payments for promotions. We do have clauses in the exceptions that have to be met there. We do have clauses that require the RGRs to set out their principles for ranging as well, and as well as the clause relating to the delisting process that Alice has just referred to. So again, if there are concerns, there's multiple ways to raise those as shown on the screen, and we are really very interested to hear if there's specific concerns, but we can't, some of the questions are asking for specific advice on a certain type of payment, and we wouldn't want to give that advice so broadly because every negotiation is very specific between the retailer and the supplier and the way that it's presented and discussed. And so we wouldn't want to give a broad comment on whether or not you could push back on a certain type of payment. Would need the context around that, and there is a good discussion to seek legal advice on as well in the context of what's been presented to you.
Great, thank you. So I think we've largely covered off those overarching questions, and we have some specifics that we will follow up on. What I would reiterate is, there are definitely a number of questions in here that relate to things that you're seeing and being offered that you have concerns about. We're very interested to hear about those things via the routes on the screen. As Catherine said, you can raise those with us anonymously or directly. And so we do look at everything that comes in, and we do make sure that we acknowledge and provide an answer. And if it's something that we feel needs further investigation, then we will go ahead and start to look at those things. So just like to finish off by thanking you all for attending. We will have this webinar available along with our fact sheets and other information on our website, and we really encourage you to keep in touch with us. We very much value the feedback, and as you can see from our review of the code, we have listened to the feedback that we received during the code review process, and tried to reflect that in the new code requirements. So we're very keen to understand how those are working in practice, and if we're being successful in addressing some of the issues that you highlighted to us. So I'd like to thank my co-panelists very much for their presentations and their question answering. And again, I'd like to thank you all for joining us, and we will hope to see you again at one of these soon. Thank you very much.